If you are a U.S. citizen, a green card holder, or a family member waiting for a visa approval, please take a moment to breathe with me. Just breathe. I know what you have been seeing this week. Headlines moving fast. Words like removed and quietly appearing next to phrases like green card protection. And I know that when you read those words, something inside you tightens. Something inside you says, is this about me? Is my status at risk? Did something happen that I missed? I hear you, and I understand why you are here. My name is Piper, and my goal today is not to give you more anxiety. My goal is to give you the quiet truth. We are going to sit here together, take this one step at a time, and we are going to separate the rumors from the reality, because you deserve real information, not panic, not noise, just the facts, spoken clearly, so that you can make good decisions and sleep a little better tonight. Stay with me. This matters. Now, before we go any further, I want to be transparent with you about something important. I am your guide today, not your lawyer, not a government official, not a spokesperson for USCIS or any federal agency. Everything I share in this video is for your peace of mind and your education, explained in the simplest language I can find. If your personal situation requires specific legal guidance, please speak with a licensed immigration attorney. That professional conversation is always worth having, but for right now, let me be the calm voice that helps you understand what is actually happening behind this week's headlines. So, what is actually going on? The phrase that has been circulating this week, USCIS quietly removed this green card protection, is connected to a specific change in how USCIS is handling a particular policy that had been in place as a form of procedural protection for certain green card applicants. Now, I want to be very careful here, because the word removed sounds final. It sounds like something was taken permanently, but the reality is more nuanced than that. And understanding that nuance is exactly what will help you today. Here is the plain language version of what happened. USCIS, which is the agency that handles immigration applications and green card processing, had been operating under a set of internal guidelines that offered a specific layer of procedural caution for applicants in certain categories. Those guidelines created an extra step, essentially a built-in pause, before certain decisions were finalized. That pause gave applicants additional time and, in some cases, an additional opportunity to respond before an outcome was recorded. What has happened this week is that USCIS has quietly scaled back or removed that procedural layer for a specific category of cases. And a federal district court, doing exactly what courts in this country are designed to do, has been asked to review whether that removal was done correctly and whether it followed proper legal process. Think of it this way. Imagine a school that had a rule saying every student got a second chance to correct their homework before it was graded. Then one day, the school quietly removed that rule without a public announcement. A concerned parent found out and went to the principal and said, "Did you follow the right steps before changing that rule?" The principal said, "Let me review that." That review is what the court is doing right now. The court is asking the government to double-check its homework. That is not chaos. That is the system working exactly as it was designed to work. Now let me answer the most important question you are probably carrying right now. Does this affect me? In the vast majority of cases, the answer is no. Let me be specific about who is most directly involved in this situation, and then let me be equally specific about who is not. The policy change being discussed primarily involves applicants who are currently in the middle of an active green card application process and who fall into a specific procedural category that relied on that extra protective step. These are people whose cases have not yet been finalized. These are people who were actively depending on that specific procedural layer as part of their ongoing application. If you are not currently in that active application window, if your case is not in that specific stage, then this change is not directly aimed at your situation. Now let me tell you clearly who is not affected. If you are a naturalized U.S. citizen, you can rest easy. Your citizenship was granted through a completed process. It is on record. It is protected. The removal of a procedural guideline in an ongoing application process does not reach backward in time and touch what was already completed correctly. Your status is solid. If you are a current green card holder whose card was approved and issued through a completed process, you can rest easy. Your permanent residence is documented. It exists in the system. A policy change about how future or ongoing applications are processed does not undo what was already approved and recorded for you. If you are a senior waiting on a family petition that has already been filed, you can rest easy. Your petition is in the queue. It is part of the record. Changes to procedural guidelines mid-process do not automatically erase petitions that were filed correctly and are already being processed. I want to say that again because it matters. Your foundation is solid. Now I want to take a moment and talk about something that I think is genuinely one of the most confusing parts of following immigration news, and that is understanding the difference between a policy pause and a law change. Because these are not the same thing, and when headlines treat them as the same thing, it creates a level of fear that simply is not proportional to the reality. A law change is a significant event. It requires Congress to act. It requires votes in the House and the Senate. It requires a presidential signature. It is a public, visible, documented process that takes time and involves multiple branches of government. You would hear about it from many sources. It would be impossible to miss. A policy change, which is what we are discussing today, is an internal agency decision. It is made within USCIS. It affects how the agency carries out its work. It can be challenged in court, reviewed, paused, or reversed. And crucially, it does not carry the same weight or the same permanence as an actual change in law. What we are seeing right now is a policy adjustment that is currently being examined by a court. The court has not yet ruled on whether it was done correctly. That examination is ongoing. And while it is ongoing, the people most directly affected have the opportunity, through the legal process, to be heard. That is the system working. That is not the system failing. The United States immigration system is like a very large ship. It does not turn quickly. It does not reverse course suddenly. It moves with weight, with deliberateness, and with process. When something changes, that change goes through layers of review, challenge, and documentation before it becomes permanent. And when someone challenges a change in court, the ship slows down even further while the navigation is checked. That slowness can feel frustrating. I understand that deeply. But that slowness is also your protection. It is the reason that sweeping, harmful changes cannot simply happen overnight without anyone noticing or responding. I also want to draw a very clear line between two words that get confused constantly in immigration conversations. The words are delay and denial. These are not the same word. They do not mean the same thing. And confusing them causes tremendous unnecessary suffering. A delay means your case is taking longer than expected. It means the system is slow. It means USCIS has a backlog that is larger than its current capacity. A delay is uncomfortable. A delay is stressful. But a delay is not a judgment on your case. It is not a signal that something is wrong. It is not a quiet way of saying no. It is simply the system moving at its current pace. A denial is a specific, documented decision. It comes with a reason. It comes with paperwork. It comes with an explanation of why the decision was made. And it comes with options. Options to respond, to appeal, to reapply. A denial is not the end of a journey, but it is also not something that happens silently, without notice, or without the opportunity to respond. If you have not received a denial notice, you have not been denied. You are waiting. And waiting, as painful as it is not the same as losing. Now I want to speak directly to the seniors watching this video. Those of you who are 60, 65, 70 years old or older. Those of you who filed a petition for a son or a daughter, a spouse, a sibling. Those of you who have been watching this channel for months or years and who carry the weight of this waiting in a very personal, very real way. I see you. And I want you to hear this clearly. The petition you filed is not invisible. The work you did to gather those documents, pay those fees, attend those appointments, respond to those requests, that work exists. It is part of a record. It does not disappear because a policy was adjusted. It does not vanish because a court is reviewing something. The law is on your side. Time is a factor. I will not pretend otherwise. The backlog is real. The wait is long. And for someone in their 60s or 70s, time feels different than it does for someone in their 30s. I understand that, and I do not minimize it. But the structure remains. The line is real. The priority dates are real. The process, slow as it is moving. And the law is on your side. Let me also talk about something that I know causes a particular kind of quiet suffering, and that is the silence from USCIS. You file your application, you pay your fees, you send your documents, and then you wait. And the silence stretches on. Days become weeks, weeks become months. And that silence does not feel neutral. It feels heavy. It feels like something must be wrong. It feels like maybe your case was lost, or forgotten, or quietly set aside. But here is what I need you to understand. No news is often just processing news. USCIS is currently handling one of the largest application volumes in its history. The agency has real resource constraints. The backlogs are documented and publicly acknowledged. And when courts get involved in reviewing policy changes, the entire system can slow down even further while those questions are being sorted out. The mail might be slow. The online portal might show the same status for months. The phone lines might give you general answers rather than specific ones. And that is okay. Not because it is pleasant, because it is not, but because it is normal right now. It is the reality of where the system is operating at this moment in time. While courts move and policies are reviewed, your application continues to exist in the system. It continues to be part of the queue. The silence is not a verdict. The silence is the system being slow. And slow, I will say again, is not the same as denied. If you are genuinely concerned that your case is outside of normal processing times, there are appropriate ways to follow up. You can check the USCIS website for current processing time estimates. You can submit an inquiry through the official USCIS online tools if your case has exceeded the posted processing window. You can consult with an immigration attorney who can review your specific case and advise you on appropriate next steps. But please, before you do any of that, check the current processing times against your receipt date. In many cases, you will find that your wait, while long, is still within the expected range for your application type, and that information alone can bring a significant amount of relief. Now I want to take a quiet moment before we close. I know you are counting the days. I know the empty mailbox feels heavy. I know that every time you open a news app, part of you braces for something difficult. I know that this kind of waiting touches your sleep, your conversations with the people you love, your ability to make plans and feel settled. I know that when you see a headline like the one that brought you here today, it lands differently than it would for someone who is not living inside this process. That weight is real, and you do not have to pretend that it is not. What I want you to also know is that you are not carrying it alone. There are millions of people in this country living inside the same waiting. Millions of people who did everything right, who followed the rules, who filed correctly, who are now simply waiting for a system that moves slowly to catch up to the life they are trying to build. You are part of that community. and that community is resilient, it is patient, and it is not disappearing. Let me bring us home now with the facts. Here is what we know. USCIS made a procedural policy adjustment this week that affected a specific and narrow category of active green card applicants. A federal court has been asked to review whether that adjustment was made correctly and whether proper legal process was followed. That review is the check and balance system doing its job. For the vast majority of green card holders, naturalized citizens, pending petitioners, and immigration applicants living in the United States, this week's change does not directly affect their status, their timeline, or their legal foundation. The immigration system is large, slow, and structured. It does not make permanent, sweeping changes without process. And when process is questioned, courts exist to examine that question carefully. What you should do is simple. Keep your documents organized. Keep your contact information current with USCIS. Stay informed through reliable sources. And if you have a specific concern about your personal case, speak with a licensed immigration attorney. What you should not do is panic, because panic is not information, and you deserve information. The system is strong, it is structured, and for the people who have done things the right way, it continues to move. Slowly, deliberately, but forward. If this video brought you even a small amount of peace today, I am genuinely glad. Please let me know in the comments below. I read every single one. Your questions shape the conversations we have on this channel, and your presence here reminds me every day why this work matters. Stay informed, stay calm, take care of yourself and the people around you, and I will see you in the next update.